What's going on, Deputy Gordon? Did you scare away Mr. Mullins? We only have half the equation here. We will get started in just a second. Just pulling everything up. All right, why don't we get started? You are Ms. Coleman?
Yes, Judge.
Ms. Coleman, nice to meet you. I'm Judge McBurney. Assume you're Ms. Hall?
Yes.
I'm Ms. Hall, Judge McBurney. Mr. Mullins, you don't have to stay standing, just saying hi. Mr. Mullins, has he had counsel at any point in these proceedings? No?
He has been non-responsive. He hasn't appeared at our status conferences. He's received notice on the e-file service list. We've mailed him notices of the status conferences as well as today's hearing.
So I'm going to the beginning here. You filed your petition in February. There's a summons, affidavit of service April. Okay. And then Judge K kicked in. There are all the orders. Order for mediation. Did you all mediate?
We have not had any response from Mr. Mullins.
Hard to mediate with only one half of the team there. Got it. So you have been doing what you need to do on behalf of Ms. Hall, but there's not any response ever. Huh. Okay. Well, why don't we start? As I understand from your petition, Mr. Mullins is behind with both child support as well as payments for healthcare expenses.
Yes.
A little north of 41,000 for the child support and a little more than 6,000 on the uninsured healthcare expenses.
At the time of the petition.
Okay, and it hasn't gotten better.
It has not gotten better. We have also accumulated the documentation of the additional uncovered medicals that he has not contributed to, which my client is prepared to testify to.
Okay.
So if I'll wait an opening and if I can square my.
Well, we can do that in a minute. I just want to make sure I'm oriented here. So part of what you're seeking is contempt, and this may explain why as I read your petition, the penalty for contempt, if I find there is contempt, is a fine as opposed to custody, which I found to be less compelling than other forms of punishment.
Yes, Your Honor. My client is seeking an incarceration order at this time because he has not paid and he has not participated. He is not. She was hopeful that in filing this action, serving him, that would wake him up.
Right.
That has not been.
It has not. Do we know he's alive?
He is alive. They have 3 children, 2 who are in college and doing well, who he's seeing, and he's alive, he's working, he's doing well. He earns a significant amount of income.
He's not doing well on the child support front, though.
Correct. He's just not being responsible.
Right. Is he local, as in?
Local, he's in South Windsor.
Okay. Well, then we can start getting things on the record, except you also are seeking to modify child support.
But we're only noticed for our contempt today. We do have a modification of support action that is also pending. Their youngest child is still under the age of 18 and in high school.
And would the modification be the amount should be changed because it's only one child, or it should be changed because of different earnings, or what?
Different earnings. We think he earns more than he did at the time of the action, as well as the expenses of the child.
But was the original child support amount based on there being 3 children receiving child support, which would be a bigger number? If we're down to 1 child, wouldn't the number be
Possibly, but
Okay.
my client would like the opportunity to determine that with what his income is. We think he makes substantially more now than he did then.
Got it. Okay. That makes sense to me. So today we're just dealing with contempt. That's all it was noticed for. Would you like to have Ms. Hall be right there or the witness stand?
I'm fine here if you're okay with it.
I'm fine. That'll work. As long as I can hear you.
Okay.
And Ms. Hall, can you raise your right hand for me? Do you swear affirm, you can say, do you swear affirm that the testimony you're gonna give today is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And can you state your full name for the record?
Nikisha Norris Hall.
Okay, and if you can speak up, just so the
Okay.
judge can make sure that he hears you. And what is your relationship to the respondent, Michael Mullins?
His ex-wife.
And you and Mr. Mullins were divorced by this court back in 2011?
Yes.
And at the time, you had 3 minor children?
Yes.
And was an order of child support entered at that time?
Yes.
What amount is Mr. Mullins ordered to pay in child support currently?
$1,787.
And is he also ordered to pay some monthly arrears?
Yes.
And what amount is he?
When you say monthly arrears, he was somehow in arrears at the time of the final order? I'm not following.
In terms of medical bills?
Well-
There's an arrears that.
I'm
DHS
sorry,
is-
$357.
$357 a month. Can you tell the court where that arrears number came from?
It came from the portal, the child support portal. So they have a section where you can see how much is owed and how much is in arrears. And the amount owed is about $50,307, and the arrears amount is $357.
And let's go over some history.
Let's not do that yet, though, because I'm still confused. So at the time of the divorce, Mr. Mullins was obligated to pay $1,780 a month for child support.
$7.
Okay, not 700, what was the number?
1,787.
787. All right, don't mean to leave off the 7. So he's supposed to pay that amount, and he was paying this arrears, or this arrears is some new number based on the fact
Based on him not paying.
not paying? Okay, so it's always been 1787, but he hasn't always paid it.
Yes.
You gave a figure of over 50,000, and what was in the petition was 41,000.
Yes.
Is it 50,000 now because the 5 more months-ish have gone by?
That's correct.
So he's already hit the 50 grand mark,
Yes,
meaning he has paid 0 in 2026.
that's correct.
When did he last pay anything?
I think it was 2024.
Okay, and yet he has been present in your, are they all daughters?
Yes.
In your daughters' lives? Okay. So the number I'm working off of is the 1787, and then there's a grand total of what's not been paid, but this 350 is just some math that DHS has done saying, hey, you need to also, not only on a forward-going basis is it 1787, but to whittle down this big number, you need to add 350.
Yeah.
Okay, got it.
And Ms. Hall, I'm going to show you what's been marked as petitioner's exhibit 1. Can you identify the document for the court?
This is a screenshot of the child support portal.
And is that a true and accurate depiction of the child support portal?
Yes, as of today.
And how did you obtain the document?
I logged into my account.
Your Honor, we would tender petitioner's exhibit 1.
It is admitted, and if you want to give me all your exhibits at once, I promise not to look ahead, but that way you don't have to come up here each time. And I can't remember, did you email exhibits to Ms. Niles so I have them digitally, or?
Not, Judge.
It's okay, we are working through the transition. A lot of the lawyers are still showing up, bringing hard copies, and we're just going to look on the screen if we have them. So I should have P1, P2, and P3. Okay, so P1 is admitted.
And Ms. Hall, pursuant to that screenshot from the portal, how much does Mr. Mullins currently owe in back child support?
$50,307.54.
And Ms. Hall, I'm going to show you what has been marked as petitioner's exhibit 2. Can you identify those documents for the court?
This is a medical bill from the Children's Healthcare of Atlanta.
Is that the accumulation of the medical bills for the minor children?
No.
No, I mean, look through.
Oh, okay. I'm sorry. Yes, yes.
Yes. And do those?
Who is Aaron M. King Mullins?
That's his now wife, his current wife.
Got it.
And are those medical bills only for your children?
Yes.
So if these bills went to her, why were you having to pay anything?
They didn't go to her, but I think her name was listed on the account as well for some reason, because they have her insurance. So the kids are insured under her insurance.
Got it. So I'll just use as an example that on this first page, your child saw Dr. Goldman Yassin, and it was a lot of money for an MRI. You paid all that, or?
It's unpaid, it's outstanding.
These are bills that CHOA is saying,
Yes,
where's the money?
yes,
Do you have insurance?
I do. Separate insurance for my children through my employer.
Your children are not part of your policy.
No.
In theory, they were part of Ms. King Mullins's policy?
Yes, so Michael Mullins, they were a part of their dad's policy, but somewhere along the line, they changed policies and now they're on, as a family, him as well, and his other kids, they're all under the policy, under her policy.
Okay, Ms. Mullins's policy.
Yes.
But for whatever reason, that policy doesn't cover this?
No.
Why are you getting bills if it's not, I'm not gonna ask how you got this, you have subpoena power, et cetera, but if CHOA is gonna go after Aaron King Mullins, why does that affect you?
They're not. This is just merely who they sent the bill to, but my name is listed as a guarantor because I'm the mother.
Oh, okay. And so CHOA might be sending notices to Ms. King Mullins, but more importantly, you're getting notices too.
Yes.
And you don't want, you want your kid to be cared for, but you don't want your credit history to be dinged
Exactly.
because CHOA, hey, we'll go after whomever, and you're one of the whomevers.
Yes.
Okay.
And have you altered the medical bills in any way?
No.
Are those true and correct copies of the medical bills as you've received them?
Yes.
Your Honor, we would tender petitioner's exhibit 2.
It's admitted. Is it tallied? This is lots of pieces of paper. Okay, good.
Ms. Hall, what is the total amount of the medical bills?
$27,930.
And your final divorce decree requires Mr. Mullins to pay 87% of the uncovered medical expenses, is that correct?
Yes.
And are you asking that he be responsible for $24,299.10?
Yes.
Which represents the 87% of the uncovered medical expenses?
Yes.
What efforts did you make to communicate with Mr. Mullins to resolve this issue prior to filing this case?
I've had a verbal conversation with him. I've sent him text messages, letting him know that he needed to provide support for our daughters. There have been times early on where I've told him, hey, I have to pay XY for a bill. And he sent money, $300, $200, whatever the bill is. But typically, that's all it's been. And it hasn't been consistent at all. So he has made no further attempt to make any payment to me at all.
And the bills that he did pay, you did not include those in your request today? Is that
No.
When you communicate with him, it's mostly via text?
Yes. Now we don't communicate whatsoever.
Why is that?
He's unresponsive.
Meaning you'll send a text
Yes.
and you get no response?
Yes.
Do you have a channel of communication with Ms. King Mullins?
No, but I have her number if I needed to, if there was an
Okay.
emergency.
And there's only now one minor child that you and Mr. Mullins share.
But we have 3 children.
But two of them are grown up.
Yes.
Right, they're grown up, they do what they do.
Yes.
But the youngest is how old?
17. She turned 17 April 25th.
So a rising senior?
Yes,
And does she reside primarily with you?
she does.
Okay, and how often does she see her father?
The
Well,
most,
let me ask that differently, because
Yeah.
she's 17, it could be when she wants.
yeah,
But is there a formal visitation schedule?
no. I mean, we have a parenting plan based on when they were younger. but
Yeah.
That was in 2011. So now, as you said, she's older. It's when they have an opportunity to. The most recent was last week. He came to take her to get her driver's license.
Okay. But it's not every other weekend I'm with dad.
No.
It's every day I'm with mom,
Yes.
unless dad shows up to take me to get my driver's license, or
Yes.
be nice when he shows up and then he's gone.
Father's Day,
Yeah.
things like that.
Okay.
And Ms. Hall, did you hire our office to file this contempt action on your behalf?
Yes.
I'm gonna show you what's been marked as petitioners exhibit 3. Can you identify those documents for the court?
These are the legal fees.
Are those true and correct copies of the invoices you've received today from my
Yes.
office?
I'm sorry to interrupt, you move faster than I do. Your parenting plan and the child support agreements that are a product of the divorce from long ago, did it have the 18-year cutoff? In other words, your 2 older daughters, he may owe, some of that 50 grand may be from when they were under 18, but he's not still owing child support
No.
for days after they turned 18?
No.
Okay, so he's got a year left, if you will, of current going
Yes.
forward for your youngest, and then all these arrearages.
Yes.
Okay, I'm sorry. Back to
No.
your bills. The part, your part.
And Ms. Hall, does that total $5,771.50 that you paid my office to date in this action?
Yes.
And are you asking that the court order that Mr. Mullins reimburse you for those expenses?
Yes.
And Ms. Hall, how has it affected you that Mr. Mullins has essentially abandoned his financial responsibility for your girls?
It has been a tremendous impact. My employer that I've been with for about 14 years now, we went through a restructuring. So
It's your employer.
Morehouse School of Medicine.
What do you do there?
I'm a manager now. I was a director, but we just went through a restructuring, so now I'm a manager. And my
Is that
salary
a
is
move up or a move down?
it's kind of down, if you will. The whole big story on that. But so now my salary has been impacted significantly, about $38,000
Really? Reduction?
reduction.
Okay. Your daughter goes to what school?
Sprayberry High School.
Is that a public school?
It is. It's in Marietta, Georgia.
Okay.
And your 2 older daughters, where are they currently?
They go to the University of Alabama. They're rising sophomores.
Are they twins?
They're twins.
And they're both at Alabama?
Yeah.
Huh.
Yeah.
Are they studying the same things and living in the same dorm?
No.
Good.
One is engineer major. The other one is sport management.
Wow, that's pretty different.
Yeah.
Good for them.
And how has Dad's lack of financial contributions affected your older daughters?
They are pretty upset by his lack of participation and helping to support them.
Why would they know about that?
They know because they got accepted into a number of schools. We narrowed it down to Spelman College here in Atlanta, and Dad had said he would cover the bill for them to go to Spelman. So about 2 weeks before they were to move into their dorm, he set up a payment plan, but he had to pay initial payment of about $30,000 and then $20,000 every month. He didn't make that payment. So
They were literally set to start at Spelman.
Yes.
And that fell apart because Dad didn't pay.
Yes. And
I'd be upset too.
yeah. So obviously I couldn't foot the bill on it, and then they had already got accepted into Alabama. All the other schools they had accepted into, the window had closed, so they couldn't attend those schools. So the only school that was still available was University of Alabama. And we worked everything out, and they were there. I mean, obviously that wasn't their first choice, but it was a good choice.
No,
So
and it's not a forever choice. They could always
Absolutely.
transfer if that's what makes sense for them.
Yeah. So with that being said, they mailed whatever the deposit that he did put down back to him, and he was very upset because he wanted them to go to Spelman College, although he did nothing to help them get there. He didn't write any letters,
Right.
didn't do anything. And yeah, he kind of just stopped communicating with them.
So he communicates with your youngest right now.
Yeah, that
And
was
where's she hoping to go to school?
Kennesaw State. She wants to be a dermatologist, so
Okay,
they're
keep
gonna
it-
go KSU to medical
All
school.
right, go Owls. Okay.
And as also part of your contempt action, are you also asking the court to enter an incarceration order for
Yes,
Mr. Mullins? And what amount are you requesting of a purge payment for him to be able to purge himself of the contempt and be released on that incarceration order?
$24,299.10.
So that's a really specific purge amount. Where did that come from?
I think she's reading the wrong number.
No, no.
Okay.
Previously spoke about a $20,000 purge amount.
Okay, yes.
For him to be, released, and then,
Do you have a good faith reason to believe that Mr. Mullins, if faced with incarceration, has the ability to pull together $20,000, whether he's borrowing from friends or family or dipping into his eye? Any legal source is okay.
Yes,
in there.
yes.
Okay.
So tell me what you know about Mr. Mullins's work history.
He's been in finance since I've known him. He was a finance major in undergrad. We both went to Clark Atlanta University together. Since he's graduated, he's worked for a lot of the big financial firms, Accenture, Deloitte and Touche, Willamette. His most recent was Goldman Sachs.
To your knowledge, has he ever made less than upper six
No.
figures? And what do you know about, since you guys have divorced, you're still raising your girls together, that to your knowledge, has he reduced his standard of living at all since then?
No.
Does he have nice vehicles?
Yes, he has a Suburban, a Tesla, and a Mercedes.
And where does he presently live?
Southwest Atlanta.
And what kind of house is that he's living in?
It's a 5-bedroom home with a gym and all the fixings.
And you know what's in his house because your daughters have been there, or he invites you
We were
over?
amicable at one point, and we did holidays together with his new family and all the relatives. So at one point we were until we weren't.
Okay.
So and he's employed to your knowledge, is that correct?
Yes, he quit his job that he was gainfully employed in to go on to pursue his entrepreneurial endeavors. And I don't know.
Meaning he left Goldman Sachs and then was going to make it on his own.
Yes,
And he's been running that consulting firm for how many years at this point?
about 2.5 years, since 2024, I believe, or 25, something like that.
Do you know Ms. King Mullins's employment status?
Yeah, she's a physician. She's colorectal surgeon, and she has her practice down in Peachtree City.
Okay.
And are you also, and I believe I went over this, you're asking the court to also order Mr. Mullins to reimburse your attorney's fees?
Yes,
And are you asking that he do that within 30 days?
yes.
And are you also requesting that Mr. Mullins be placed on a payment plan for the arrears in addition to the current support of $1,000 per month?
Yes,
The payment plan you're saying is $1,000 a month?
Yes, sir.
Okay.
After the $20,000 purge. Are there anything else that I've missed that you are requesting of the court today?
no.
Your Honor, I do believe that is our case.
Ms. Coleman, how have you in the past seen an order entered that includes a contempt sanction of incarceration when the contemnor is not here? Is it an order and there's a warrant attached, or
Right.
how does it get enforced? It's kind of toothless unless Deputy Gordon delivers it, and then he would deliver it and say, you need to come with me.
Right, Your Honor, and unfortunately, I've had a lot of experience with this because, people who know that they're about to get an order of incarceration often will not show up for
Right.
the purpose. But the court enters the order and then it goes into GCIC and you hope that he gets pulled over for a traffic ticket or has some other encounter, or hopefully appears in court one day on this action and then gets taken into custody. But I don't think it's toothless because it's still an incarceration order.
Their teeth are just sort of out there.
Right, it's
But
out there until he's.
you think that an order, I guess because you've experienced it, it actually goes into GCIC? Like if I sign an arrest warrant, that goes into GCIC, but this would be different unless it is accompanied with an arrest warrant. What have you seen in the past?
And Judge, I don't work in the, the back office is the intricacies of the court.
Yeah.
But I can find out. I know that whatever is done, it does get put into GCIC. Because
Okay.
with the order, we also put the identifying information,
Good.
all of those things. So from my understanding, it does go into GCIC.
Okay, I'll ask around. I'm sure some of my colleagues have had to deal with this, like you've dealt with it on the front end, but they'd be dealing on the back end saying, oh, I'd like my order to have some impact. And that would mean figuring out how to get it into GCIC and beyond. So you'll get me a proposed order in Word format. You can send that to Ms. Niles. And then is the modification matter, has it already been scheduled as well through Judge K, or it's still working its way through Judge K?
I think we're reset for 60.
Okay, so you're in his able hands and you'll be managing that for Ms. Hall.
I know she was asking about the logistics of the order that we were just speaking about.
Oh, okay. Trying to think if there's anything else. The few times on the civil side of the work I've done where there was a need to get someone in custody, like a juror not showing up or an attorney being in pretty serious contempt, the sheriff's office said, we need a picture. We can't just have the descriptors, height, weight, age, eye color, skin color, et cetera.
Photo as well.
Okay, so I'll reach out for that if I need it. You don't need to send it, but you'd be able to get a relatively current photo?
Yes, Judge.
Okay,
Yeah.
and not like with his arm around his daughters, but it would be, okay.
Right, because we sent one with our processor.
Oh, okay, then you're, okay. You're equipped. Well, I think that's everything. Ms. Hall, I'm sorry you're having to work through this. I'm sorry about that hiccup at work too. That's no fun. But at least the answer was I still have a job because I work with people and like they right-sized and they right-sized me out the door. It's not the outcome you were hoping for, but you're still there. Your daughter now has a driver's license. Yikes, good luck with that. At least she waited a year. I have a 15-year-old who, when he is 16 and 1 second, wants to have his driver's license. Like you could wait for a little bit, but actually him being able to get himself to some of the places he needs to get will be nice. I don't know if your daughter does sports, but I have to drive my guy all over Kingdom Come.
Yeah.
And so once it's safe, it'll be great when he can do that. But I'm sorry you've had to struggle around this. That's not how it's supposed to be. And I'm sorry Mr. Mullins wasn't here because he may have had something to say about it. I'm not following it given his financial circumstances, but I'm coming to learn that emotions often get in the way of what's right and what's possible. And then you're forced to bring in your very capable lawyer to have to pull these levers that fortunately are there. It's just too bad that they need to get tugged on. Ms. Coleman, anything else?
I don't believe so.
Then I will look for that order from Ms. Niles. If I have questions, I'll make sure. When you send, I don't know if you had any correspondence with us. Did you always copy whatever email you have from Mr. Mullins? Okay, so it's on his radar.
Yes, even the confirmation that this hearing was going forward on time today.
Yeah, good. Oh, because you had a conflict.
I had a conflict.
I'm glad you worked through that because we got through this.
Got us right on out.
All right. So once I get that order, I will massage it and talk with colleagues and maybe someone in the sheriff's office to figure out what's the best way to make this effective. And if I need anything else, we'll reach out.
Thank you, Judge.
Thank
All
you.
right. You guys take care.
You too. Hope our division is treating you well thus far.
Well, it's 1 week in.
I was telling my client, I was like, hey, just transitioned over last week.
Yep. So far, I don't think I've messed anything up for anyone, but we'll see. Let me know when you get the order.
Thank you.
All right, bye-bye.
Have a good one.
That was Deputy Gordon. I mean, it was only one witness that I saw for, close to 2 hours.
So it's this funky cross section, and you know a lot about the case, but you don't know what necessarily what the charges are.
Well, it's a murder, so.
It is a
I
murder.
don't know a lot about the lead up, but my understanding, I guess, and when I talked to one of the other interns, it's someone was shot. We know that, but we don't know how exactly it happened.
Okay. Good afternoon.
Your Honor.
Can you all hear me?
Yes, Your Honor.
Yes.
Great. Let me get us started in just a sec. All right, so this is a contempt hearing in the matter of, is it pronounced Negron?
Yes, Your Honor.
Mr. Negron versus Ms. Pinkney. And is it Bussert?
Yes, Your Honor.
Mr. Bussert represents Mr. Negron, and I'm going to get Mr. Bussert on the screen there. And then I believe, Ms. Pinkney, you now have counsel, and that may be Ms. I'll let you pronounce your last name.
Yes, Your Honor. It's Chauvet Maldonado.
All right, so it's French and Spanish. Chauvet Maldonado. Thank you for joining us. And I see Mr. Negron. Is Ms. Pinkney on? She's on as well. Good, we've got everyone. So here's what I am. I'm Judge McBurney. I'm new to the case. This was a Judge Ellerby case as of July 1. Her docket became mine and my docket became hers. So I'm coming in a little late to the process. But what was scheduled for today is a hearing on a contempt issue. Ms. Pinkney, until just a few days ago, represented herself in connection with the petition that Mr. Negron had filed. And in representing herself, she relied on AI to draft some of her pleadings. And as is often the case, AI invented some things and stretched some things. Ms. Pinkney, are you a lawyer by trade?
Your Honor,
Yes,
Ms.
sir.
Pinkney is not a lawyer, and we can actually clarify the AI issue.
Well, I'm going to give you a chance to do that in a
Okay.
sec. I'm just
Okay,
sort
great.
of setting the table so that you and Mr. Bussert can say, no, that's not what we're doing, or yes, that's what we're doing. Ms. Pinkney is not a lawyer, and her pleadings included a few things that weren't accurate, hallucinations, whatever you want to call them. I don't get the sense that Ms. Pinkney herself made it up of whole cloth. Hey, I'm going to create this case, but AI did. And of course, Mr. Bussert, in doing his good work, is trying to figure out, well, what's this case? I'm not familiar with it, and does it really stand for that proposition? And try as he might, he couldn't find it because it doesn't exist. And Judge Ellerby had some pretty clear instructions about how to use AI and how not, and how to certify that you did, et cetera. And she set the hearing down today, not for us to get into the substance of the dispute between Mr. Negron and Ms. Pinkney, but really to talk about what the consequences ought to be for Ms. Pinkney to have used AI without certifying it or acknowledging it. And I think more fundamentally, but again, it was Judge Ellerby's rules, letting some bad information sneak through, and then signing her name to it, effectively saying, I swear this is accurate. So I think that's what we're here to do. Mr. Bussert, I'm going to start with you to let me know if you think, nope, we're actually here to talk about child support modification.
Your Honor's summation is correct. We're here on the show cause order regarding Ms. Pinkney's use of AI and the hallucinated citations and misrepresentations of statutes.
Okay, got it. Ms. Chauvet Maldonado, anything you want to add to just sort of procedurally why we're here, what's going on?
Excuse me, Your Honor, I neglected to unmute myself. Your summation is generally correct, but we would like to clarify a few points related to the citation error with hopes that the court will be understanding of how this all came about. Thank you.
Okay. Great. Well, why don't you do that? I'd like to hear from you, and then I will hear from Mr. Bussert. And then we also need to make a plan for going forward. Let me pull this up, the docket, because I want to make sure before we sign off, we're also all aligned as to what's next. Because I think this all flowed out of a motion to reconsider something that had been done, and it was in that motion for reconsideration, maybe that some of these hallucinations crept in. So, Ms. Chauvet Maldonado, why don't you share with me what you wanted to?
Your Honor, Chauvet is fine in the interest of being brief. So good afternoon, Your Honor. My name is Chanel Chauvet Maldonado. I'm appearing on behalf of Respondent Adrian Rochelle Pinckney. We appreciate this opportunity to clarify in this court's hearing to show cause. Now, before I get started on how this all came about, and I understand that I have just 30 minutes to clarify, I do want to note that respondent acknowledges the citation issue. She accepts responsibility for the filing, and she respectfully submits that the court record reflects that there was an inadvertent mistake, not necessarily a bad faith filing, nor any attempt to mislead the court. I hear a bit of an echo, so I would kindly ask that my opposing counsel mute himself.
I'll take care of it. All right.
Okay, thank you. So with respect to acknowledging the citation error, now there was just one citation in the motion for reconsideration that could not later be verified. This error was inadvertent and not an attempt to mislead the court. And actually, as soon as respondent learned about the issue or realized the issue, she promptly corrected the record by filing an amended motion in which she withdrew reliance on the citation.
Ms. Chauvet, did Ms. Pinckney figure out that it was a bad citation because she went behind the work she did and double checked it? Or did it come to her attention because Mr. Bussert had to file a motion saying, I don't even know what I'm dealing with here. There's this case, I can't find it anywhere. I think we've got an AI issue, Judge.
No, Your Honor, and I'll actually explain how this all came about. She filed it within, I think it was within 1 or 2 days, and this was before Sean Bussert ever filed a response. So again, it was not in response to any filing from opposing counsel.
Okay.
And again, I'll get to how this all came about. Now, I noted that she acknowledges the error. I think it's important to note for the purposes of this hearing that respondent has authored her own pleadings. In fact, she has an extensive educational background, including a PhD from Emory University, which demonstrates the experience she has in writing generally. Also, this isolated error is inconsistent with any sort of inference that opposing counsel listed in his brief of any intentional deception, as the isolated citation error was simply an oversight and is not evidence of respondent's lack of authorship of her filings or that she intended to deceive the court. Now, regarding how this all came about, Your Honor, while researching on Google, respondent encountered the citation in her Google search. There's a new feature called Google Overview. And after searching for case law on the platform related to the issue that she was attempting to bring to the court in her motion for reconsideration, she mistakenly believed that it was valid. Admittedly, she did fail to independently verify it before filing it, but when she later attempted to verify it and realized that she could not verify it, and also realized that the overview provided to her in the Google search was actually a new AI feature that the platform has added to its Google searches. So once she realized all of this, she immediately withdrew reliance on it, again, within 1 to 2 days, and she filed that amended motion. With that being said, she does still accept full responsibility for this mistake, but I wanted to share the overview about how this all came about and how she immediately corrected it upon learning about this new feature. Now, regarding good faith for the basis of her motion, she filed this motion for reconsideration to present additional sworn evidence relevant to jurisdiction. Now, the motion was based upon a genuine dispute regarding the proper forum under the UCC JEA. Importantly, the parties' mediated settlement agreement reflected that as of August 2025, both parties contemplated that the children would reside in Raleigh, North Carolina, and that the father, petitioner, intended to relocate there so that the parties could exercise equal parenting time. Now, respondent relocated in reliance upon those representations and believed that North Carolina had become the children's home state. Now, although that particular agreement was never incorporated into a final order because the underlying action was dismissed without prejudice, respondent relied upon those representations when relocating their children. So this provides important context for why respondent later believed in good faith that North Carolina had become the appropriate forum under the UCC JEA. Now, the evidence address regarding the children's residence includes records related to school enrollment, medical care, and the parties' mediated agreement concerning relocation to North Carolina. The motion itself reflected a genuine legal disagreement regarding jurisdiction, not any sort of delay, harassment, nor abusive process. Further, when North Carolina became the children's home state, she actually filed an action in North Carolina prior to ever being served regarding the Georgia action, because she genuinely believed in good faith that it was the proper forum. Respondent filed her North Carolina custody action on February 11th, 2026, earlier this year. This is after North Carolina became the children's home state, and respondent was not served with the Georgia action until late March earlier this year. So probably about 2 weeks to a month after she had filed the North Carolina action. I do want to note for the court's attention that the North Carolina custody action is pending before Judge Crystal Grimes, with a hearing scheduled for September 9th, in just about a month. And petitioner has appeared through counsel in that action. So communication between those courts will actually help avoid future conflicting issues, including potential custody orders. We respectfully request that if the court reaches jurisdictional issues, that it confer with the North Carolina court pursuant to OCGA 19-9-66. I have just a few more points, if you'll bear with me. The next point relates to the good faith argument under OCGA 19-9-67. Now, Georgia law expressly permits a court to decline jurisdiction if Georgia is an inconvenient forum. Now, respondent's motion address factors.
I'm going to object at this point. We've gone beyond the show cause hearing. We're trying to get into jurisdictional issues that have now been ruled on twice.
Your Honor, I'm explaining how this all came about and why.
Okay, stop. Okay, got it. I don't need additional context. I am looking at Judge Ellerby's order dated May 5, 2026, and the law of this case that binds me, a co-equal, co-peer of mine, indicated that this is the appropriate forum for this litigation. We're going to have a conversation this afternoon about what are we going to do about the fact that there is a North Carolina case about custody going on as well. But I'm aware, Ms. Chauvet, that Ms. Pinckney very vigorously, in a perfectly appropriate way, challenged jurisdiction and pointed to all the reasons why North Carolina was the appropriate forum for any custody dispute between Mr. Negron and Ms. Pinckney. That's not what Judge Ellerby decided. And so here we are and here we stay. But I feel like you've provided sufficient context as to why Ms. Pinckney was seeking to have Judge Ellerby reconsider the order denying the motion to dismiss and the motion to stay. That's not what Judge Ellerby did. And so that ship has sailed. And what we're working through today narrowly is what are the consequences, if any, of the, I'm going to call it over-reliance or misreliance on AI. You've shared with me that you believe, or Ms. Pinckney tells you that she didn't know it was AI. It was computer-aided research, either way. And we need to sort out what all that means. We'll also, on a broader topic, figure out what are we doing next in light of what you shared with me, which is a September hearing date on the custody case, for the custody case in North Carolina. So if
Yes,
there's
Your
anything
Honor.
more you want to add about the misrepresentations that were in the motion for reconsideration, I'm happy to hear about that.
Yes, Your Honor. Perhaps I can proceed with why sanctions are not appropriate here.
Great.
Okay. First and foremost, there is no evidence of bad faith, nor that this was a frivolous filing. In fact, the mediated agreement is useful insofar as it explains in good faith why respondent believed that North Carolina was the proper forum and why her motion was filed in good faith, not necessarily because it independently created enforceable custody rights. Since
Well,
October.
I don't believe Ms. Pinkney engaged in a debate about jurisdiction in bad faith. I think she was perfectly justified in doing so. It's just not the argument that carried the day with my predecessor. So
Yes.
you don't need to convince me that there was vexatious litigation or harassing litigation. That's not what I see here. And Mr. Bussert will respond in a minute, but if he's going to take the tack that, gosh, Ms. Pinkney is one of these, because we have AI litigators who just go on and say, give me 5 motions that will make the other side's life more difficult. And AI spits out 5 motions that'll make, and that's not this at all. I understand why Ms. Pinkney was pressing for the outcome she was pressing for. It was well placed and it was well reasoned. Whether it's because she's a PhD from Emory or because she got assistance, doesn't really matter. It was very well reasoned. It just happened to not comply with some pretty clear directives from Judge Ellaby about the use of AI or Google Assist or whatever. And so it's really that narrow. Ms. Pinkney is not appearing in front of me behind some 8 ball of, why were you saying it shouldn't be in Georgia? I'm not possessive about cases, and I understand entirely. She's in North Carolina. The kids are in North Carolina. If you just put them in the scales of justice, look where the weight is. It's all in North Carolina. But again, that's not the ruling that was made. So let's stick to the, what do we do about the fact that that brief, that motion to reconsider didn't comply with Judge Ellaby's instructions?
Yes, Your Honor. Thank you. In fact, the reason I mentioned it is because if you view opposing counsel's brief, it does seem to indicate that there has been a series of frivolous filing, this being the case here, and that also he's permitted sanctions or attorney's fees, I should say, because of that issue. So I did want to address it as it relates to sanctions and why they're not appropriate. I do also want to note for the court's attention that my client has already incurred significant litigation costs in this dispute, well over $60,000, and has received no child support to date. In fact, since August of 2025, respondent has been the sole caregiver and financial provider.
Stop, both of you stop. When you hear an objection, you got to stop talking. And I'm a little confused. You piqued my curiosity, not about the child support, because that's not what we're here to talk about. But the sense I got from looking in the docket, but I did not look in the older docket to which this case relates. Ms. Pinkney's been representing herself, and it is a cardinal rule that you don't get to collect your attorney's fees if you're self-represented. In what context did Ms. Pinkney incur 60? I mean, you may have a real high retainer, and that could be the 60,000. But if that's not it, where are legal bills coming from in this case?
So, Your Honor, I am actually appearing on a pro bono basis, given my client's financial situation. She has incurred attorney's fees through the guardian ad litem case, and then also through previous filings. She had another attorney that she engaged prior to this that helped to support her in a series of meetings, including the mediated settlement agreement.
Got it. Okay. Well, I appreciate your appearance on her behalf in the manner that you're doing it. And so those are legal fees from the case that preceded this action.
Yes, Your Honor.
Okay, Got it.
Okay,
All
so
right,
in
how about we
closing,
do this? I'm gonna pause you. I want to hear from Mr. Bussert a bit. I'm gonna give you a chance, Ms. Chauvet, to respond. If you feel like Mr. Bussert has taken us out of focus from whether there should be sanctions, and if so, what they should look like for the miscitation of one case. And I know from reading his brief, he believes that there was some elasticity given to a couple statutes. And so I'll hear him on that. But I think some of what you were starting to share with me was more predicting what it was that Mr. Bussert was going to hear about. But I'm going to give you the last word. And that way you'll be able to clear up anything that you think Mr. Bussert might have made cloudy through his presentation.
thank you, Your Honor. And if I could simply note, I was actually getting ready to close with 4 last points. Not sure if you still want to proceed in the same way.
Why don't you save the 4 last points? I will hear them when I pivot back to you.
Okay.
Great. Mr. Bussert, good afternoon.
Good afternoon, Your Honor, and thank you. I do want to offer at least one point as to the court's belief that there was not bad faith in this. The parties litigated, just as a very brief background, the parties litigated a case for 9 months previously before Judge Ellerby that ultimately resulted in a mediated agreement. But there's a very material portion of that mediated agreement that respondent and now her counsel seem to want to glass over. And it's specifically that in the consent order that was submitted, it says in the event that this case is dismissed, this consent order and corresponding documents referenced herein and contained in Word format between counsel via email on September 24th, 2025 shall operate as a binding agreement that shall be resubmitted for the court's approval in a new action filed in Fulton County Superior Court. The parties agree that Fulton County shall continue to have exclusive jurisdiction over this matter until the entry of a permanent parenting plan.
Was the case dismissed? I thought that the previous case was in fact resolved, and then I got to hear about everyone's moving to North Carolina, and based on that, Ms. Pinckney moved there with the kids. So I'm confused. I thought the previous case, or maybe technically it was settled because it was a mediated resolution, or was there a consent order in the end that was a byproduct of the mediation?
So,
Your Honor,
Nope. It's a question for Mr. Bussert. You'll get a chance in a minute.
So as the only counsel present that was here as a part of Judge Ellerby in that original case, the parties at the 120-day status conference announced that they had reached a full settlement because it was our understanding we had. In preparing the parenting plan, the child support addendum, the consent final order, and all the other additional documents, there were a series of 4 to 5 paragraphs on 2 pages of the parenting plan that were not agreed to. The parties through counsel reached out to Judge Ellerby and asked for her assistance, or at least to schedule a telephone conference to adjudicate the disagreements regarding those 4 to 5 paragraphs. Judge Ellerby's response was, you announced that there was a full settlement. If I don't have these documents by a date certain, I'm dismissing the case.
Okay.
So respondent was bound by her previous attorney Moskowitz, to that consent order where her counsel expressly agreed in negotiations with me that those documents would be resubmitted for litigation in Fulton County. So that's the only background that I want to provide as to whether there's bad faith going on.
And so I'm trying to follow here because I'm playing a lot of catch up. This action, the 26 CV action that you file on behalf of Mr. Negron, is basically what you're describing. It's getting this consent order language back in front of, it would have been Judge Ellerby, but she's moved on. Okay, so it's the reincarnation or the relitigation that was envisioned where there was the agreement that, and when this happens, it's in Fulton County.
That is correct.
Okay. I'll continue to hear from you, but I'm going to pause you. Ms. Chauvet, you are new to the case as well. In some ways, a little newer than I am, but clearly you've dived in deeper than I have. what do you have to say about there being some binding agreement that further litigation about custody and parenting plan, et cetera, was agreed to be based here in Fulton County? I'm not, if you don't know that because you haven't probed the earlier case, that's fine. I'm not trying to get you to commit. But if you say, oh yeah, no, that's exactly what everyone agreed to, then I guess I'd need to press you on a few other issues.
Your Honor, I'm not aware of that. What I did say earlier at the outset was that the agreement was never incorporated into a final order because the underlying action was dismissed without prejudice. And respondent relied upon those representations when relocating their children to North Carolina. As part of this agreement, both parties agreed to move to North Carolina. So again, this provides important context for why respondent later believed in good faith that North Carolina had become the proper forum and pursuantly submitted that motion for reconsideration.
Got it. Thank you. Mr. Bussert, I want you to keep going, but you were providing some helpful context that I think you, other than the two actual litigants, but they're not going to be talking right now, are uniquely positioned to provide as the lawyer who's been involved with both. What is there in writing that backs up what you're saying, that basically everyone agreed if this gets dismissed, the 25 CV gets dismissed, and it's going to be brought back, we all agree that it would be brought back in Fulton rather than whatever county Raleigh is in?
Your Honor, I have the documents that were previously drafted as a part of that case. I can also provide the court with the email string between counsel related to that issue. If necessary, I can subpoena Attorney Moskowitz to appear at a future hearing. There were written emails, communications confirming this was the agreement of between counsel, which is binding on the parties pursuant to case law, that this would be the only purpose of this litigation, that respondent is now greatly expanded. And again, the continued representations that she had understandings otherwise are just not borne out by the express agreements reached by her attorney.
Well, they're not necessarily mutually exclusive. So it sounds like you've got written backup, and I wasn't pressing you because I disbelieved you. That's not the case. But other than the agency aspect, and I'm not challenging you on that either, that if Attorney Moskowitz said, here's how it's going to work, he's empowered to bind his client. That doesn't mean his client knows that that has happened. And so if I'm thinking about good faith, bad faith, if Ms. Pinckney wasn't aware of it, then I'm not so sure we jumped to the conclusion that she did it out of bad faith. Now, if confronted with it, she persists in, for example, the North Carolina litigation. I'm sort of confused how that could still be going on given the existence that you claim of these arrangements, because it seems like that would be proof sufficient to extinguish a North Carolina case. And yet it's moved far enough along that there's a hearing in front of a judge in a couple months. So that part's a little confusing to me, but other than the fact that the lawyer does legally bind the client, do you have any reason to believe that Ms. Pinckney knew that that was the situation, or understood it? Not because she doesn't get legal things, but her lawyer's talking to her a mile a minute and say, hey, this is going to be dismissed. We've reached this settlement, blah, blah, blah. And it may have mentioned something about, and if we relitigate this, it's back in Fulton. She's thinking, now time has passed and I'm not relitigating anything. So I'm curious why you think she was fully aware of that.
Well, Your Honor, at minimum, and if you'll forgive me for 1 second, I'm pulling up the original petition that was refiled in this case. But at minimum, respondent was aware of the binding agreement prior to her filing the motion for reconsideration. because I specifically cited and in bold included it in my original response to the motion to dismiss.
Okay.
However, I will also note for the court that the original petition for legitimation, custody, parenting time, and child support in paragraph 2 stated respondent is a resident of the state of North Carolina and is subject to the jurisdiction and venue of this court by virtue of the Uniform Child Custody Jurisdiction Enforcement Act and the prior settlement terms negotiated between counsel. And then this was again brought up before Judge Kay, who is the judicial officer for Judge Ellerby at the 30-day status conference. Now, at that time, Ms. Pinckney had already filed a motion to dismiss that I had said I was planning on responding to and filed a Rule 1004 motion, which is what has led us here. But I believe if she were questioned under oath, she would admit that she was fully aware of those terms.
I'm just looking at your response to the motion to dismiss and seeing it in big, bold. It's also italicized, so it's extra emphasized. Okay. All right. And that was the response to the motion to dismiss. And so your point would be, all right, maybe the motion to dismiss, she didn't realize what the posture was when that previous case was dismissed, or didn't remember. But once you've put that in 14-point bold italics, and then there's a motion to reconsider, you're getting into that space of frivolity.
That is correct.
Okay, I better understand your argument now. You can keep going.
And what I will really point out to the court, and I guess I'm one of the only remaining attorneys that wants to stand on this soapbox, but the rise and prevalence of AI is a bane to society, and the fact that it continues to permeate the judicial system represents the fact that courts and bar associations refuse to, in my opinion, properly hand out punishments for the use of AI that really should be resulting in disbarment going forward. But that being said, respondent was pro se at the time, but this representation that, she accidentally used an AI search engine while her counsel is also saying, well, she's really good at writing stuff and she's got a PhD from Emory. Those two things can't be true at the same time. Either she has the ability to research and to write, or she doesn't. This isn't someone who has an associate's degree or something like that. They can clearly see what is in the documents that they're searching. And a reasonable person would say, all right, well, let me go look for the case that I'm seeing just so I can make sure that it's correct, as someone who's had to defend apparently their dissertation. But outside of that, there is and this is arguably what makes this situation worse. The only thing that counsel and Ms. Pinckney are taking responsibility for are the ghost citation. There has been no conversation or discussion related to, as the court generously put it, the elasticity of statutes cited, which Judge Ellerby clearly agreed with when she set this down for a show cause hearing. Respondent said that the 19962A1 provides that neither the child nor the child and one parent maintain a significant connection with Georgia beyond mere physical presence. That is not the citation of that statute. Just plain and simple. And there has been no, I'm sorry, I misrepresented statutes. It's, this was an incorrect case. I realized it pretty soon after I filed the motion. Please forgive me for this case. That would make it seem like the rest of the motion was correct. It wasn't. that 19962A1 states the statute states that either of the child's parents have a significant connection with the state. So long as one parent maintains substantial connection to the state retains jurisdiction. And I cited in my response DeVito v. DeVito 280 Georgia 367 that was decided in 2006, where the court specifically held that a child that had been absent for 2 years was still bound by Georgia jurisdiction because one of the two parents didn't move out of the state. So the requirement is both parents move out of the state. That is not the case here, and that citation was a fabrication. It wasn't elasticity. The only way you could use that statute in support of her position is to change the wording of the statute, which is exactly what she did. And this entire
Objection, Your Honor. That's speculation.
Well, I'm gonna let you, we glossed over the statutory citations when you and I were interacting. So when I pivot back to you, I'm gonna let you talk about that.
And again, I mean, that's not the only issue before the court. There was an additional reference to an indication that the court in future UCC JEA proceedings was required to go through some sort of analysis as to, respondent specifically stated that continuing jurisdiction is not indefinite and must be reevaluated when the factual circumstances underlying the children's connections to the original forum materially changed. The statute requires the court to examine both whether children and at least one parent continue to maintain significant connections with Georgia and whether substantial evidence concerning the children's present care, protection, training, and personal relationships remains available within Georgia. None of that is correct. It is if one parent, again, the case law is clear, the statute is clear. If either parent remains in Georgia, Georgia continues to have jurisdiction no matter what the situation is. I was not able to find a single case. Now, maybe they exist. I was able to find it. And the case I did find did hold that a child more further away than these children was still subject to the jurisdiction of the court. But, and I guess to some extent, this really goes beyond the original issues. I mean, I'm going through, so I guess it's a twofold argument. A, there's ghost citations and complete fabrications or blatant misrepresentations of not just a case, but code sections. And the pretrial brief that respondent filed does not even though Judge Ellerby's order addresses the fact that I pointed out more than just the case citation, respondent does not acknowledge that she completely fabricated those other positions that are still in the amended motion that she filed. So she clearly has no shame as a result to filing of those pleadings.
Well, I'd like us to stay out of the shame, no shame. That's not what we're here for. And I'm not attributing that to Ms. Pinckney. I think she when she was a pro se litigant, was doing her level best to represent her position. It sounds like partnering with AI, she inadvertently or purposefully took some liberties with what statutes say and what cases are there. I'd like to know what you think the consequences ought to be, Mr. Bussert, and then I'm going to turn back to Ms. Chauvet to let her talk about the statutory citations or miscitations. And she said she had 4 points in closing she wanted to cover.
So, Your Honor, as the court, I know the court is just coming on to the family law bench, but a unique aspect of family law that is different than other civil litigation is that the striking of pleadings ultimately doesn't serve any purpose in family law because the court is always required to go through whatever analysis is related to the original pleading or to the counterclaim. So the only thing available to the court, if the court's going to order a remedy, is an award of attorney's fees. The singular exhibit that we submitted was a request for attorney's fees in the amount that had been incurred prior to date of $2,042. To the extent that Respondents Counsel wants to cross-examine me, I can put that up as the exhibit 1 of $2,042. And with the additional hour that we are in court today, that would bring the total to $2,417 that we are asking the court to award in terms of attorney's fees pursuant to 915.14b. Obviously, due to the failure to comply with the court's requirements regarding AI usage, but B, because at least as it relates to the motion for reconsideration, it was entirely frivolous because any argument that she may have had prior to the original motion to dismiss was gone as a result of my response that clearly identified the parties' agreement. Outside of that, I've been an attorney practicing exclusively family law for going on 11 years now. I bill at a rate of $3.75 an hour. I've been recognized as a rising star in super lawyers for the last
Objection, Your Honor. Relevance.
So, Ms. Chauvet, he needs to do this unless you are choosing not to challenge the reasonableness of his attorney's fees. And if you, I'll let you know, based on his experience, that hourly rate seems reasonable, but unless you stipulate that it's a reasonable rate, he's got to tell me a little bit about his qualifications and any honorifics he's got, because that goes into the weighing I do to say $3.75, that's crazy. You're a first-year associate and you've never handled the case versus you've been practicing law for over a decade in this field. You've been recognized as whatever he was about to say. So if you're not going to be challenging his qualifications, I'm happy to cut him short.
Your Honor, we do not challenge his qualifications. This is something that I actually investigated in the past day since I've joined this case. It seems reasonable, although all of his other arguments are pure conjecture, and I'm looking forward to responding to each of them.
All right, well, you'll get that time in just a moment. So, Mr. Bussert, it looks like your exhibit is good to go, and then we would add an hour to that 2042 figure.
Yes, Your Honor.
Okay. All right. Anything else on behalf of Mr. Negron?
No, Your Honor.
All right. Ms. Chauvet, you have listened patiently, so you can do at least two things. One, any response you've got to what I just heard from Mr. Bussert. And then two, you had said you had 4 points you wanted to close with, and I promised you we'd come back to those. And so I'm here to do that. And then anything else you can fit into the remaining 10-ish minutes.
Yes, Your Honor. Thank you for the opportunity to respond. I understand that we are at the close of the business day, so I will aim to be succinct. Now, regarding the citation error, again, it was inadvertent. It was not intentional.
When you say citation error, you mean to the case, or are we now talking about the statute?
We're talking about the case.
Okay.
Again, the motion for reconsideration was filed to present additional sworn evidence relevant to jurisdiction. It was not a frivolous matter. It was based on a genuine dispute regarding the proper form pursuant to the UCC JAA. The motion itself reflected a genuine legal disagreement regarding jurisdiction, not delay, not harassment, not abusive process. Again, I want to reiterate that respondent actually filed her North Carolina custody action on February 11th. This was about a month before she ever received notice about this Georgia action. She has a hearing that's pending September 9th, and any matters related to the statute itself, and I'm hearing a bit of an echo, is pure misinterpretation of the statute, which can occur with pro se litigants. It was not intentional by any means. In fact, there is a more appropriate statute here concerning why North Carolina is a more appropriate forum under OCGA 19-9-67, but I will leave it at that given the amount of time remaining.
Okay.
So In closing, I want to again ask the court respectfully to find that the citation error was inadvertent rather than intentional, deny petitioner's request for sanctions and attorney's fees, as the motion for reconsideration was intended in part to bring evidence to light of the parties' intentions and expectations via the mediated settlement agreement, in which both parties noted and agreed to move to North Carolina by December 27th of 2025. This was not a frivolous filing. And I think it's also important to consider the equitable financial circumstances presented and the impact that it would have to 3 young children, a 3-year-old and twin 5-year-olds that have been solely supported by respondents.
Objection, Your Honor.
If
91514B, which is the relief requested, doesn't take into consideration financial circumstances.
Okay, I will, if I'm going to be relying on a statute that requires me to take into consideration financial circumstances, I will certainly ask both sides to provide additional information on that.
Yes, Your Honor. Moving onwards. If appropriate, we also respectfully request that North Carolina, per Code 19-9-66.
Objection, Your Honor. This is a show cause hearing. This is not anything to do with North Carolina.
Okay, well,
Your Honor,
I
it's
don't even know what
related.
her point was yet, so just hold off, Mr. Bussert. Let me hear what she's going to say, and then I can process whether I need to rely on that. So if you'd start that sentence over again, you were given a citation. I couldn't tell if that was going to be a North Carolina citation or Georgia, so take me through it again, please.
Your Honor, before I was interrupted, I was going to say that this is in relation to the point that there are 2 actions that are simultaneously occurring. So to your point about the next steps, if appropriate, we respectfully ask that the court confer with North Carolina per Georgia Code 19-9-66 before making any sort of jurisdictional determination moving forward. And then grant any other relief as the court deems appropriate. Thank you.
Okay. Thank you for that. Mr. Bussert, give me your thoughts. I'm curious, what is your connection, if any, to the North Carolina litigation? You're aware of it, you actually are barred, and so you are representing Mr. Negron there, or what's happening with that case from your client's perspective, as best you know?
The extent that I have any information is when he was served with that action, he retained local counsel in North Carolina, and I had maybe a 15-minute conversation with them probably about 3 months ago, and or 2 months ago, it was some time ago, and have not had any further conversation, mainly to the point of there is no conversation to be had because Judge Ellerby has ruled now twice on this issue, and it appears that respondent's attorney is now asking the court to engage in this analysis a 3rd time. But to be clear, all of this would ignore the binding agreement between the parties.
Okay, I got that, and I'll sort out the Georgia end of things, but it sounds like you don't know if there is in the docket in North Carolina a motion to dismiss from your client because of what you say is the binding agreement that jurisdiction, everyone's agreed that jurisdiction for this dispute is here in Fulton.
I do not. I will, to the extent that it keeps being brought up, I will note that the filing in North Carolina did not meet the 6-month requirement because there is this continued reference to February 11th. The parties there was a guardian ad litem.
What's a 6-month requirement?
So to the extent we're going to invoke the UCCJEA, and that the new home state of a child would be determined, let me back up. When there is an initial determination of jurisdiction, this does not apply for exclusive continuing jurisdiction, but for the determination of initial jurisdiction, the court has jurisdiction where the minor children have resided for the last 6 months. And that is the argument that respondent appears to be relying on, although Judge Ellerby twice has said Fulton County has exclusive jurisdiction regardless of whether the settlement agreement is binding or not, which it is. So, I mean, Judge Ellerby determined that court had exclusive jurisdiction regardless of the settlement agreement. We're contending the court has jurisdiction both under continuing and under the binding agreement. But to point out again, as the history of this case, there is a standing order that goes into place when these cases are filed in family court. That order is that the children are not to be removed from the jurisdiction of the court absent agreement or order of the court. There is a guardian ad litem, Patricia Shoemaker, who specifically said that she did not consent to those children being removed from the jurisdiction except for the purposes of a visitation or vacation period. The parties did not reach a mediated agreement that would represent the finality of these issues until August 20th. So the first date, if we're going to say Fulton County did not have exclusive continuing jurisdiction, if we're going to say that there was no binding agreement that she was bound to by her counsel, she still had to wait until February 20th, which was the day the parties reached the mediated agreement authorizing the children to move. So she would have to refile that case in order to invoke UCCJA. And that has also been brought up.
But I appreciate the argument. We just don't know the status. We do know the status. There's a hearing in a couple months. And according to Ms. Chauvet's understanding of the docket there, it's alive and well. Mr. Negron has counsel. It's not you. I, of course, am not imbued with the authority to tell North Carolina what to do with its case. It might not be a bad idea to check in with that judge, but that doesn't mean that I am ceding jurisdiction to that judge or anything like that. But it's certainly not efficient for your client or for Ms. Pinckney to be fighting the same battle in two fora. That's not how it ought to work. So I'm a little surprised if everything is as you're describing, Mr. Bussert, why the North Carolina case persists. But North Carolina law is not Georgia law. Maybe there's a reason, and we'll see. But I really don't mean for you or Ms. Chauvet or Mr. Negron or Ms. Pinckney to have to wrestle with the ultimate issue of custody and parenting and whatnot in two different places. That's in no one's interest.
Your Honor, if I may add just a couple points.
Okay.
So Judge Ellerby actually denied the previous motion due to issues with the exhibits. This was back in, I want to say, either March or April, which is part of the main reason why my client decided to file the motion for reconsideration for all the reasons that I indicated earlier with respect to my argument for good faith. Also, in terms of good faith, we respectfully rebuke the personal attacks against Ms. Pinckney. Yes, she is educated, and educated folks use Google quite often to research statutes, for example. The UCCJA is publicly available. So are a series of cases. She was not aware that Google added a new AI feature entitled Google Overview. So again, this was a genuine mistake. It's something that she has been extremely apologetic about, and we respectfully ask the court to be cognizant of that in making its final determination.
Okay, well, I appreciate that. We're going to bring this to a close. I will note this so no one is surprised by any ruling that's going to flow from this. There's nothing magic or mystical about this AI concept. The issue here is the presentation to a judge of material that isn't what you say it is. And whether it came from AI or, I mean, heck, back in the olden days, probably well before some of you all, if you didn't shepherdize, you pick out the wrong book and it's from 1872 and that's what the case law was, and you don't know that in 1905 they changed it. You cite that 1872 case, there's no AI, there's no computers, there's electricity in the lights and that's it. But that's sanctionable, as in you could be in trouble for it because you didn't do your homework on this. And so I'm not wrapped around the AI mantle. And did Ms. Pinckney know that there was an AI agent assisting Google? She got information from a source, the credibility of which she knew could be called into question, because you can go into Google and say, what should I do about COVID? And you could find, take pesticide. That doesn't mean you should take pesticide, but that's out there. And then you need to verify. And clearly that verification didn't occur. So I don't attribute to Ms. Pinckney some lack of education or anything like that, because she relied on information from the internet. In fact, that's a smart thing to do, as long as you are cautious about how you use what you get. And I think Mr. Bussert is not out of line in pointing out that there was a lack of caution here. Once it was recognized, some of it was corrected. I think the harder part to correct was maybe the over-reliance on some authorship around what statutes say and don't. But the die's been cast, that's been filed, and I need to figure out what the consequences are for filing something like that in the face of Judge Ellerby's very clear directions about relying on information that you don't take the time to verify. So I will get an order out soon on this. Next steps for this case would be, there was
The parties had
Going to be a
recently-
conference with North
you have a
Carolina
120-day status conference on
in
the
August.
with me. All right. So we will be together then. My recollection, as I'm climbing this steep learning curve here, is that you all must meet. Oh, you've got your order for mediation. So you all will mediate before that status conference. Just so everyone's clear, I don't want there to be any surprises. That is sanctionable to show up at the 120 and not have mediated. So if one side's planning on being difficult, I'm not talking about the lawyers, I'm talking about the clients. Just know that a refusal to sit down at the table doesn't end well at that 120 conference. One of the first things I ask is, how did mediation go? And if mediation didn't go well, that's okay. That happens sometimes. But an answer of, we didn't mediate because person X wouldn't show up, that's a bad outcome for the person who didn't show up. So take care of that. I will see you all on the 20th of August. I'll obviously have an order in place on this well before then. Ms. Chauvet, you are counsel of record for Ms. Pinckney until you withdraw. I appreciate that you are right now out of your own largesse assisting Ms. Pinckney with things. But until you file to withdraw, I'll be turning to you for responses, for an appearance at the 120 day, et cetera. So I look forward to that. Is there anything else? I'll just start on petitioner side, Mr. Bussert, that we need to cover to clear up any confusion or to make certain what deadlines are and expectations are for the Georgia case?
No, Your Honor.
Okay. Ms. Chauvet, anything from your side?
Yes, Your Honor. Concerning the status conference on August 20th, will this be in person or online?
It is virtual.
Virtual, great.
Yeah, you're welcome to be in person, but the default is virtual.
Okay. And then concerning the conference with North Carolina, again, there are 2 actions pending. Is this something that the court will take into consideration in terms of resolving jurisdiction?
Yes and maybe is what I would answer. I would like you, please, to share with Ms. Niles, my staff attorney, obviously copying Mr. Bussert on anything you send, the case information about North Carolina, by which I mean only style of the case number, and most importantly, judge and any contact information you have for that judge, whether it's an email for the judicial assistant or staff attorney. But even if you hadn't asked for it, my plan is to reach out to that judge to say, all right, what's going on? I don't want our trains to collide on the tracks.
Yes, Your Honor.
So we will do really what we ought to do when the same matter is pending in two jurisdictions. I would do this if this were a car crash case or a criminal case. I don't know how that could happen, or a family case. We won't talk about jurisdiction, but we will talk about who's doing what next and all that. So that would be very helpful. I think that's it. Thank you, everyone, for dialing in. Mr. Negron and Ms. Pinkney, we didn't get to talk, but that's not the purpose of today's hearing. I appreciate your attendance as well. And you all will also be online for the 120-day status conference. It's infrequent that I meet with the lawyers without the clients, so that we protect the lawyers from a scenario where they go back and tell you and you say, I don't believe that's really what happened. You're gonna hear it from me. And you can fuss at the lawyers about what a wingnut I am, but at least you've heard it from me and not filtered in some way through the lawyers. So I will see all four of you at the 120-day conference, and we will go from there. Mr. Bussert, last chance. Anything else?
Nothing else, Your Honor.
Thank you for your time. Ms. Chauvet, anything else?
Yes, Your Honor. Should I contact Ms. Nails about the information for the August 20th status conference?
We will push something out to you all about the Zoom link and what you need to be prepared to discuss at the conference. So you'll get something from us.
Okay, thank you very much.
All right. Thanks, everyone.